By the time the white SUV rolled over my curb, 3 men in black jackets were already marching toward my front porch, like they had every legal right to be there. The words Community Safety Enforcement were printed across their backs, but there was no county seal, no sheriff's badge, no marked patrol car, and no warrant in anyone's hand. Behind them stood Marla Whitcomb, our HOA president, arms folded, chin raised, watching with the satisfied look of someone who thought she had finally cornered me. The man in front slapped a printed notice against my door and said the HOA had authorized an emergency safety action. I had 45 minutes, he told me, to open my gun safe and surrender every hunting rifle in my house until the board decided whether I was fit to keep them in the neighborhood. He used words like compliance, seizure, community risk, and temporary custody, but he was not law enforcement. He was a private guard pretending HOA paperwork gave him police power. When I asked for a warrant, he smirked and said HOA authority was enough inside Pine Hollow Estates. Then one of the other men stepped closer, leaned toward the glass, and reached for my door handle, like intimidation was part of the job. The whole street seemed to freeze. A neighbor stopped watering his lawn. Blinds lifted 2 houses down. Someone's dog started barking from behind a fence. Marla raised her phone, clearly hoping I would lose my temper on camera, so she could call me unstable in front of the entire neighborhood. But I did not shout. I did not open the door. I did not threaten anyone. I just kept recording their faces, their jackets, their vehicle, their license plate, and every word coming out of their mouths. Then I told them there was one thing they should have checked before sending fake guards to my home to confiscate legally owned firearms. I was a federal ATF agent. The lead guard's face changed first. The smirk vanished. The second man backed away from the door, so quickly his boot slipped off the edge of the porch. The third suddenly stopped touching his jacket logo, as if covering it now would erase what my cameras had already captured. Marla's smile disappeared, though she still tried to say this was an HOA matter. It was not. Within 3 weeks, that fake enforcement notice would become Exhibit A in a legal demand letter. The security company would lose its contract. The HOA board would be dragged into an emergency meeting, and Marla Whitcomb would learn that private property rights do not vanish just because an HOA president gets embarrassed. Before that morning, I had done everything possible to be invisible in Pine Hollow Estates. I was not the guy who argued at HOA meetings. I was not the neighbor who measured everyone's grass, complained about trash cans, or posted angry paragraphs in the community Facebook group. I bought my little ranch-style house because it sat on a quiet curve at the back of the neighborhood, with oak trees behind the fence and just enough space for a workshop, a grill, and a life that did not follow me home from work. Most people in the neighborhood knew almost nothing about me, and I preferred it that way. They saw my old pickup in the driveway, saw me mowing on Sunday afternoons, saw me leaving early on weekdays with a travel mug in one hand, and probably assumed I worked some boring government desk job. That was fine with me. My work had enough noise, enough risk, and enough people pretending the rules did not apply to them. Home was supposed to be the place where I could breathe. The house mattered to me because I had earned it slowly. Every repair, every fence board, every light fixture, every inch of that yard came from overtime, patience, and years of not buying things I wanted, so I could afford something that was mine. The small detached workshop behind the house had a county permit. The safe inside it was bolted down, locked, and used exactly the way it was supposed to be used. My hunting rifles were legal, secured, and private. One had belonged to my father. Another had been passed down from my grandfather. They were not props, threats, or political statements. They were family property. Hunting tools and memories. That was what made Marla Whitcomb's obsession so insulting. Marla became HOA president about 8 months after I moved in at first. She seemed like every other overorganized board member with too much free time and a binder full of rules. Then the letters started. A warning because my trash bin was visible from the street 20 minutes after pickup. A notice because my pickup had dried mud on the tires after a hunting trip. A fine because a storm knocked a branch onto the sidewalk while I was at work. I answered politely. I sent photos. I paid nothing I did not owe. I tried to keep things civil, but Marla did not like polite boundaries. She treated them like rebellion. The real problem started with Derek Voss. The neighbor, 2 houses over Derek's dog kept getting loose and tearing through my flower bed. When I asked him to fix his gate, he acted like I had accused him of a crime. A week later, he told people at an HOA meeting that I owned firearms, not that I had done anything wrong, just that I owned them. Marla took that rumor and turned it into an campaign. Suddenly, I was not Ethan Cole, quiet neighbor with a pickup and a well-kept yard. I was a safety concern. I was a liability. I was the reason families supposedly felt uncomfortable letting their kids ride bikes near my street. If you have ever dealt with an HOA that twists one private detail into a public accusation, you already know how fast a neighborhood can turn into a courtroom without a judge. And if this story sounds familiar, leave a comment with what you would have done before things reached the front porch. Because I still thought common sense would stop it. Then I opened my email one Friday evening and saw a message from the HOA with the subject line, Mandatory Safety Compliance Inspection. The email looked official enough to scare someone who did not know better. At the top was the Pine Hollow Estates logo, followed by a bold red line that said Immediate Community Safety Action Required. Under it, Marla had written that the HOA board had received multiple reports regarding dangerous materials allegedly stored on my property. She did not say hunting rifles. She did not say firearms. She used the kind of vague language people use when they want something to sound worse than it is. According to the notice, I had 48 hours to provide a written inventory of all firearms, ammunition, and related equipment inside my home or workshop. Then I was supposed to schedule an inspection with a community safety representative so the HOA could determine whether my property met neighborhood standards. I read it twice, then a third time, because the wording was almost unbelievable. The HOA was not asking me to move a trash can. They were not asking me to repaint a mailbox or trim a hedge. They were demanding information about legal property stored inside my locked private home. Then they wanted permission to inspect it. I replied the same night. I told Marla that the HOA had no authority to demand a firearm inventory, no authority to inspect the inside of my home, and absolutely no authority to regulate legally owned hunting rifles stored in a locked safe. I kept the message short, professional, and boring. I wanted every sentence to look clean if a lawyer ever had to read it. Marla answered less than 20 minutes later. Her response said my refusal would be treated as non-compliance. She claimed the HOA had a duty to protect families from undisclosed hazards. Then she added that if I failed to cooperate, the board could impose daily fines and hire private personnel to secure the matter. That phrase stayed in my head. Secure the matter. People who respect boundaries do not talk like that. By Monday, the situation had spread through the neighborhood. Derek Voss had posted in the private Facebook group that certain residents were hiding weapons behind technicalities. He never used my name, but everyone knew who he meant. One woman commented that her kids should not have to live near an arsenal. Another man asked if the HOA could force me to move out. I watched the thread quietly and took screenshots of every post. Then the fines started. $500 for refusing a safety disclosure. Another $500 for obstructing a community inspection. A third notice warned that continued refusal could result in emergency corrective action. None of those phrases appeared in the actual bylaws. They were invented words wrapped around fake authority. On Thursday evening, Marla came to my driveway while I was unloading groceries. She did not come alone. Derek was with her, standing a few feet behind like a man who wanted a show but not responsibility. Marla held a folder against her chest and told me, loud enough for nearby houses to hear, that I was creating fear in the community. I told her calmly that my personal property was none of the HOA's business. Her face tightened. She said, "You live in a managed community, Mr. Cole. You agreed to rules when you bought here." I told her I agreed to architectural standards and common area maintenance. I did not agree to give a neighborhood board access to the inside of my gun safe. Derek laughed under his breath and said, That sounds exactly like something a dangerous person would say. That was the first time I felt the anger rise in my chest. Not because they disliked me, not because they were gossiping, but because they had decided that a private, legal part of my life could be twisted into a public accusation. They were not looking for safety, they were looking for control. Marla opened her folder and handed me one final notice. It said Sentinel Neighborhood Patrol had been contracted to conduct a compliance visit Saturday morning. If I refused access, the notice claimed the HOA would document my refusal as an admission of unsafe storage. I looked at the paper, then at Marla. I asked her if she had run this by an actual attorney. She smiled and said, "You can hire one if you think you can afford it." That sentence told me everything I needed to know about her. She was not confused. She was not acting out of concern. She thought money, pressure, public embarrassment, and fake paperwork would make me fold. Saturday morning, Sentinel arrived exactly at 9. 3 men stepped out of a white SUV wearing black jackets with official-looking lettering. Marla waited on the sidewalk, already recording with her phone. Derek stood near his mailbox, arms crossed, pretending not to enjoy himself. The lead guard told me the HOA had authorized him to take temporary custody of my hunting rifles. He said the items would be held until the board reviewed my risk status. When I asked what law gave him that power, he tapped the paper in his hand and said, "This is the authorization." I asked again for a warrant, he said. "We don't need a warrant. The HOA supersedes that inside this neighborhood." That was the moment I knew they had crossed from harassment into something much bigger, because threatening fines is one thing. Sending private guards to a homeowner's door to demand entry and confiscate legal property is another. So I stopped trying to convince them. I stepped back, kept the door locked, made sure my cameras were catching every angle, and let them keep talking. The moment the 3 men backed off my porch, the entire scene changed. They had arrived like they were there to enforce the law. They left like they had just realized they had been recorded breaking the illusion of authority they were depending on. The lead guard folded the notice in half with shaking hands. The second man kept looking at the cameras mounted under my roofline. The third turned his jacket inside out before he even reached the SUV, as if hiding the words on his back would somehow erase what had already been captured. Marla stayed longer than they did. She tried to keep her posture straight, but her confidence had cracked. She looked from me to the cameras, then down at her phone. And for the first time since this started, she did not look like someone in control. She looked like someone trying to calculate how much damage had already been done. I did not chase them. I did not stand in the yard and lecture them. I did not call them frauds in front of the neighbors, even though half the street was watching from windows and driveways. I closed the door, locked it, and started preserving evidence. The first thing I did was download the full video from my front door camera, the side camera facing the driveway, and the small camera inside the workshop entryway. Then I copied the footage to 2 separate drives and uploaded another copy to cloud storage. I saved the original files with timestamps intact, because I knew edited clips could be dismissed as drama, but clean footage with metadata was something very different. Then I photographed everything they had left behind. The tire marks across my curb, the scuff on my front step where one guard had slipped backward, the printed notice with the HOA logo at the top, the name Sentinel Neighborhood Patrol printed near the bottom, the signature block under Marla Whitcomb's name. I also wrote down a timeline while the memory was fresh. What time the SUV arrived, which man spoke first, what words they used, who reached toward the door where Marla stood when Derek came out to watch. I did not trust myself to remember every detail perfectly a week later, so I treated the first hour like the foundation of a case. After that, I opened my laptop and pulled every HOA email into a separate folder, the original compliance notice. Marla's reply claiming my refusal would be treated as non-compliance, the fines for obstructing an inspection, the final warning about emergency corrective action. I printed them all and highlighted the phrases that mattered most. Safety seizure, temporary custody, secure the matter, refusal as admission. Those were not normal HOA words. Those were words designed to make a homeowner believe a private board had power it did not have. Then I went back to the governing documents. I read the CC, ARS, the bylaws, the rules and regulations, and every amendment that had been filed with the county. The section Marla kept pointing to was called Dangerous Materials and Hazardous Storage. It mentioned fuel drums, exposed chemicals, fireworks, flammable construction waste, and unsafe outdoor storage. It did not mention legally owned hunting rifles. It did not authorize indoor inspections. It did not allow private guards to demand entry. And it absolutely did not give the HOA the right to remove personal property from a locked home that mattered, because Marla S.'s entire position depended on making a vague rule sound bigger than it was. I contacted a civil attorney who handled HOA disputes and property rights cases. I gave him the videos, the emails, the notices, the screenshots from the neighborhood Facebook group, and the names of everyone who had been present. I also made one thing clear. I was not asking to wave my job title around like a weapon. I wanted the matter handled cleanly through the proper channels, with every fact documented and every step above board. I also notified my own chain of command that a private HOA contractor had attempted to pressure me into surrendering legally owned firearms at my residence. I did that not to escalate the neighborhood drama, but to avoid even the appearance that I was hiding a conflict. When your work involves federal law enforcement, you do not improvise when civilians show up at your house, pretending they have seizure authority. Later that day, I called the sheriff's office non-emergency line and reported the incident. I explained that no one had entered the house. No physical confrontation had occurred, and I was not requesting some dramatic response. I simply wanted an official record that private security personnel had come to my property, claiming authority to confiscate personal property without a warrant or lawful order. Then I started looking into Sentinel Neighborhood Patrol. What I found was not impressive. They were registered as a private neighborhood patrol company, the kind hired to write parking reports, observe common areas, and call actual law enforcement when something serious happened. Their own website described their services as visibility patrol, incident documentation, and community presence. Nowhere did it say they could conduct searches. Nowhere did it say they could seize property. Nowhere did it say they could act as an enforcement arm inside private homes. The man who led the group was named Grant Keller. His name appeared in 2 old complaint threads from other subdivisions. In one, residents accused him of threatening to tow vehicles from private driveways. In another, someone claimed he had implied he was working with the sheriff's office when he was not. None of it proved what happened at my house, but it told me this was not the first time Sentinel had enjoyed standing close to the line. My attorney sent a preservation letter to the HOA that same week. It demanded they keep every email, text message, invoice, meeting note, video, contract, and internal communication related to me, my property, the so-called safety inspection, and Sentinel Neighborhood Patrol. It also warned them not to delete the Facebook posts or alter the meeting minutes. That letter did something my calm replies had not done. It scared them into silence. For 2 days, Marla sent nothing, no fines, no warnings, no neighborhood announcements. Derek deleted his Facebook post, but I already had screenshots. Sentinel stopped driving past my house. The board canceled its regular meeting and announced an executive session instead. That was when a resident I barely knew left an envelope in my mailbox. Inside was a printed copy of a draft HOA memo and a handwritten note saying Marla had pushed this plan before anyone voted on it. At the bottom of the memo was a sentence that made my attorney pause when I sent it to him. The purpose of the compliance visit was to establish control before Mr. Cole influences the community. That was when I understood the truth. They were never afraid of my hunting rifles. They were afraid I would tell the neighborhood they had no right to demand them. The legal turn did not come from one dramatic confession. It came from paperwork. That was the part Marla never understood. People like her loved paperwork when it made them feel powerful. Notices, warnings, fine letters, violation forms, red stamps, bold deadlines, but paperwork cuts both ways. Once you put a threat in writing, you cannot pretend later that it was just a misunderstanding. My attorney started with the document the lead guard had slapped against my door. At first glance, it was designed to scare a homeowner. It had the Pine Hollow Estates logo in the corner, a fake case number, a bold title that read Notice of Safety Enforcement Action, and a paragraph claiming Sentinel Neighborhood Patrol was authorized to secure, remove, and hold hazardous private items pending board review. It even had a line near the bottom saying failure to comply could result in escalation. But the more my attorney read it, the worse it looked for them. The HOA was not a court. It was not a sheriff's department. It was not code enforcement. It was not a federal agency. It had no power to issue an order that looked and sounded like a seizure notice. And Sentinel had no power to stand on my porch and imply they could take legally owned property from inside my home because Marla Whitcomb felt embarrassed at a board meeting. Then we compared that notice to the actual HOA documents. There was nothing there. No inspection power for firearms. No authority over items stored inside a locked safe. No emergency seizure procedure. No rule allowing private security to enter a home. No clause allowing the board to treat refusal as admission of guilt. The entire operation had been built on language Marla invented, and pressure Sentinel was willing to apply. That was the first crack. The second crack came from the contract between the HOA and Sentinel Neighborhood Patrol. My attorney obtained it after sending the preservation letter. The contract was narrow, very narrow. Sentinel was hired to observe common areas, report parking violations, document noise complaints, and contact law enforcement when necessary. Their employees were specifically described as non-law enforcement personnel with no arrest or seizure authority. That sentence changed everything, because Grant Keller had not merely misunderstood his job. He had stood at my door and claimed authority his own contract said he did not have. The third crack came from the video. My front camera captured Grant saying clearly and loudly, "We don't need a warrant. The HOA supersedes that inside this neighborhood." My side camera captured Marla standing behind him, not correcting him, not stepping in, not acting surprised. She nodded while he said it. That one nod mattered. It showed she was not watching some contractor go rogue. She was approving the message. Then the resident who had left the envelope in my mailbox contacted my attorney directly. He had been on the Board S Rules Committee before Marla pushed him out. He provided notes from a closed meeting where Marla argued that the HOA needed to make an example out of me before other residents started challenging board authority. One line from those notes stood out. Uniformed presence will make compliance easier. That was the moment the whole story shifted. This was never about safety. If they had truly believed there was a danger, they could have called the sheriff. If they had a real legal concern, they could have consulted counsel before sending anyone to my home. If they thought I had broken a law, there were proper channels. Instead, they hired men in jackets to scare me into surrendering private property. My attorney sent the demand letter on a Tuesday morning. It went to the HOA board, Marla, personally, Sentinel Neighborhood Patrol, and the HOAS insurance carrier. Attached were the videos, the notices, the contract language, the screenshots, the deleted Facebook posts, and the notes from the meeting. The letter demanded that the HOA immediately withdraw every fine, retract every accusation, preserve all records, identify everyone who approved the compliance visit, and confirm in writing that no representative would come onto my property again without lawful authority. It also made one thing clear: if they tried to frame this as a misunderstanding, we were prepared to show exactly how many people had participated in creating it. By that evening, Pine Hollow Estates changed tone completely. The same board that had been sending me threats suddenly asked for a respectful pause while counsel reviews the matter. Marla stopped emailing me directly. Derek deleted 3 more comments from the Facebook group. Sentinel S. White Sioux V disappeared from the neighborhood patrol route. Then my attorney received a call from the HOAS lawyer. He did not defend the notice. He did not defend the guards. He did not defend Marla's claim that HOA rules superseded warrants. He simply asked whether I would be willing to resolve the matter privately before the next public board meeting. That was when I knew they had finally read their own documents, and for the first time since this started, they understood something I had known from the beginning. An HOA can enforce rules about fences, paint colors, lawns, and mailboxes. It cannot invent a police department. The sheriff's office did not arrive with sirens. That was not how real authority looked. Real authority showed up on a weekday morning in a Plain County vehicle with a deputy holding a notepad, a calm voice, and the patience to watch the footage from beginning to end. He stood in my entryway while my attorney played the porch camera video on a laptop. No one interrupted. No one added drama. The room was quiet except for Grant Keller's voice coming through the speaker. "We don't need a warrant. The HOA supersedes inside this neighborhood." The deputy looked up at that line. Then he asked my attorney to play it again. After the second time, he wrote something down and asked for copies of the notices, the emails, the Sentinel contract, and the names of everyone who had been present. I gave him the timeline I had written the same morning it happened. He appreciated that more than any emotional speech I could have given. A few days later, the state licensing office that oversaw private security companies opened its own inquiry into Sentinel Neighborhood Patrol. That was when the blame started moving faster than facts. Sentinel claimed the HOA had misled them. The HOA claimed Sentinel had acted too aggressively. Marla claimed she had never intended for anyone to enter my home. Grant Keller claimed he was only using standard compliance language. Derek suddenly claimed he had only been concerned for the children. Everybody had a version of the story where they were innocent. Unfortunately for them, the evidence had timestamps. The HOA's insurance carrier got involved next. That changed the mood immediately. Insurance people do not care about neighborhood gossip, personal grudges, or Marla's wounded pride. They care about liability, documents, and whether someone created a risk the policy might not cover. Once they saw the fake enforcement notice and the footage of private guards demanding access to my home, the board's tone went from defensive to terrified. Then came the emergency HOA meeting. I almost did not attend, but my attorney told me it mattered for the record, so I sat in the back row while residents packed the clubhouse wall to wall. People who had ignored every previous meeting suddenly wanted answers. Some were angry because they thought the HOA had gone too far. Others were nervous because they realized if Marla could do this to me, she could do something just as reckless to them. Marla sat at the front table, pale and stiff, with the HOA's attorney beside her. Derek sat near the aisle with his arms crossed, but he kept his eyes on the floor. The meeting started with the usual language about community standards and safety. Then a resident stood up and asked one simple question. Did this board authorize private guards to confiscate property from inside a homeowner's house? No one answered. That silence did more damage than a confession. Finally, the HOA attorney leaned toward the microphone and said the board was reviewing whether proper procedures had been followed. The room erupted. One man shouted that proper procedures did not explain fake seizure notices. A woman near the front said Marla had used the same intimidation tactics over parking fines and backyard sheds. Another resident admitted he had paid hundreds of dollars in penalties because Sentinel told him refusal would make things worse. For the first time, Marla was not controlling the room. She tried to speak, but every sentence made it worse. She said she was protecting families. Someone asked why she did not call the sheriff if she believed there was a real threat. She said the board had to act quickly. Someone else asked why there was no board vote. She said the situation was sensitive. My attorney quietly slid a copy of the Sentinel contract across the table to the HOA lawyer. After that, the HOA lawyer requested a recess when the board returned. The president, who once stood on my sidewalk smiling while fake guards threatened me, now had to sit in front of the entire neighborhood while a written statement was read into the minutes. The HOA withdrew the fines. It suspended all enforcement activity related to the so-called safety inspection. It terminated Sentinel from any further neighborhood duties pending review. And it confirmed in public that no HOA representative or contractor had authority to enter a private home or seize personal property without lawful authority. Marla did not look at me once while it was being read, but I did not need her to. The record was finally saying what I had said from the beginning. The consequences did not land all at once. They came in waves. First, the HOA withdrew every fine connected to the so-called safety inspection. The $500 penalties disappeared from my account. The non-compliance warning was removed. The accusation that I had created a community hazard was formally retracted in writing for the first time since Marla started this campaign. The record no longer treated me like the problem. Then the settlement discussions began. The HOA agreed to reimburse my initial attorney fees, pay for the minor damage to my front step, and issue a written statement to residents explaining that the board had no authority to inspect private firearms storage, demand inventories of legal property, or send contractors to seize anything from inside a home. The statement was dry, careful, and obviously written by lawyers, but it said what mattered. They had overstepped. Sentinel Neighborhood Patrol lost its contract before the month ended. Their white SUV stopped circling Pine Hollow Estates. Grant Keller was suspended from field duty while the state licensing office reviewed the complaint. I later heard Sentinel lost 2 more neighborhood contracts after board members in other subdivisions saw the video and decided they did not want that kind of liability parked at their gates. Marla held on for another week. At first, she tried to frame herself as a victim of bad advice. Then the meeting notes surfaced. Then the emails surfaced. Then residents learned she had pushed the uniformed compliance visit before the board ever took a valid vote. By the next public meeting, even her usual supporters were silent. She resigned as HOA president with a 2-paragraph statement about personal stress and a desire for community healing. No one applauded. Derek Voss had his own smaller fall. My attorney sent him a letter about the Facebook posts, where he had implied I was dangerous without evidence. Derek deleted the comments, posted a stiff correction, and suddenly became very interested in keeping his dog on his own property. Funny how fast people discover boundaries when consequences finally have their name on them. As for me, I did not celebrate by making speeches or waving my badge around. I replaced the scratched weather stripping near my front door. I added another camera facing the driveway. I put the printed apology in a folder with the rest of the documents, because experience had taught me that peace is easier to enjoy when you can prove what happened. If someone tries to rewrite it later, my hunting rifles stayed exactly where they had always been, locked, secured, legal, and private. People ask me afterward if Marla lost because I was an ATF agent. The answer is no. Being an ATF agent made those fake guards panic, but it was not what beat them. Evidence beat them. Their own words beat them. Their fake notice beat them. The contract they ignored beat them. The rules they twisted beat them. The law beat them, because they were arrogant enough to think HOA power could replace it. That is the lesson I took from all of it. You do not have to be the loudest person in the neighborhood to protect your home. You do not have to threaten anyone. You do not have to play dirty. You need clean records, calm decisions, the right documents, and enough patience to let reckless people put their arrogance in writing. And if an HOA, a neighbor, or a contractor ever shows up at your door acting like your rights are optional, remember this story. Record everything, ask for authority, read the rules for yourself. Get help before you react, because the people who rely on intimidation are usually terrified of one thing: a homeowner who knows where the line is. If this story made you think of an HOA that pushed too far, leave a comment with what you would have done on that porch. Share it with someone who needs the reminder, save it for later, and subscribe for more stories where ordinary homeowners win not by shouting louder, but by standing their ground the right way.